Ladies and gentlemen, thank you very much for joining us, and it's an enormous pleasure to welcome you to the second part of today's conference. Hopefully, David Hope will reconnect in a second. And what we're going to be doing in this half of the session is look at some issues arising in relation to contractual construction. We're very honoured to have three excellent speakers, or possibly two, who are going to guide us through some of the knottier problems in this area. We look at whether the current law is striking the right balance. They are Charlotte Tan, Lord David Hope, and Lord Leonard Hoffmann. Charlotte is a busy junior who joined Brett Court from another commercial set of chambers back in March. She regularly appears in high-profile commercial litigation, and her cases have included Deutsche Bank and Sebastian Holdings and the Cengiz litigation. The legal directories include several quotes saying that she's very regularly seen at hearings outmatching opposing QCs with her advocacy. As one of her potential opponents, that's all rather alarming, but I'm sure she'll be kind today. Charlotte is going to be giving us a short reminder of some of the key cases on contractual construction and the principles they establish. Our next speakers will be Lord Hope and Lord Hoffmann. David Hope practiced at the Scottish Bar and was a member of the Faculty of Advocates for 24 years. In 1989, he was appointed direct from the bar as Lord President of the Court of Session and Lord Justice General of Scotland. He was appointed as a law lord in 1996, and in 2009 became Deputy President of the Supreme Court when that court was established. David sat as an appellate judge for 24 years, and for 17 of those years served with distinction as a member of the UK's highest court. Among the various other things, he's decided a large number of the leading cases on contractual construction and remoteness of loss. So it's a huge privilege to have David hopefully join us today. Lenny Hoffmann became a High Court judge in the Chancery Division in the 1980s before moving up to the Court of Appeal in 1992, where he stayed for only 3 years before becoming a law lord. He too has decided a number of the leading cases on contractual construction, including Investors' Compensation Scheme and West Bromwich. His speech draws together the key principles for interpreting contracts. The legal directories said, amongst other things about Lenny, that he is, and I quote, competent in commercial law. That may be the only occasion in which the directories have been unduly modest. David and Lenny are going to discuss a number of examples and some of the issues arising out of the case law. If you have any questions for them, please send them through on the chat function, and we'll try our best to get back to them. So with no further ado, I'll hand over to Charlotte, who's going to give us an introduction to the legal issues.
Thank you, Nick. Establishing the meaning of a contract is a balancing act. It involves weighing up competing considerations, for example, the natural and ordinary meaning of the words, the purpose of the contract, or whether one meaning or the other fits better with commercial common sense. And these different factors may very well pull in different directions. And the challenge for the practitioner and the court is to decide how the balance between these factors should be struck. So, for example, should the natural and ordinary meaning of the words be given primacy? Or can the meaning of words only really be determined by reading them against all the background in which they were used? A convenient starting point for answering this question is Lord Hoffmann's landmark judgment in ICS and West Bromwich, which the other lords in the majority, including Lord Hope, agreed with. Now, given that I have the privilege of speaking before Lord Hoffmann and Lord Hope themselves, I am loath to try to summarise the statement of principle myself. But just in the interest of avoiding reading out a long quote, perhaps I might just highlight the following points. So, point 1. Interpretation is the ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties at the time. Point 2. The background includes absolutely anything which would have affected the way in which the language of the document would have been understood by the reasonable man. Let's skip down to point 4. The meaning of a document is not the same thing as the meaning of its words. The meaning of words is a matter of dictionaries and grammars. the meaning of the document is what the parties using those words against the relevant background would reasonably have understood them to mean. Then point 5, the rule that words should be given their natural and ordinary meaning reflects the idea that we do not easily accept that people have made linguistic mistakes, particularly in formal documents. But if the background shows that something must have gone wrong with the language, the court is not required to say that the parties intended something which they claim it did not. So, just pausing there, the overall approach mandated by ICS is that the inquiry should not be limited to simply reading the words used, and that in an appropriate case, you may have to look at all the background. And background means absolutely anything which would have affected the way the reasonable man would have understood the language used. Now, that judgment then set the scene for a fierce debate in the following decades as to how to weigh up the language of the contract against any competing background considerations. And just taking a step back and trying to get a bird's eye view of the nature of the debate, well, the starting point is there are a number of factors that fall for assessment in deciding the meaning of a contract, and I've listed them there on the slide. Point 1, the natural and ordinary meaning of the clause. Point 2, whether any other relevant provisions of the contract assist in a textual interpretation of the disputed clause. Point 3, the overall purpose of the clause in question and the contract more generally. Point 4, the relevant factual background. And point 5, the business or commercial common sense of the rival meanings. But point 6, it is irrelevant to consider evidence of the parties' subjective intentions, and that generally includes evidence of pre-contractual negotiations. But that then raises difficult questions of where the borderline lies between improper pre-contractual negotiations and legitimate factual background, and also whether there are any exceptions to the prohibition on pre-contractual negotiations, for example, in relation to establishing the genesis or purpose of the contract. Now, there are difficult questions in relation to each of those factors, some of which will be debated later in the session. But for now, the point that I want to consider is how those various factors should be balanced. Now, the textualist would say that primacy should be given to the natural and ordinary meaning of the words. And a clear supporter of that view is Lord Sumption. In his 2017 Harris lecture, he called for the reassertion of the primacy of language in the interpretation of contracts. The contextualist would say that, well, one can only really understand the meaning of words by looking at the context in which they are used. So to understand the meaning of the contract words, you have to look at the words in the light of the surrounding circumstances, which includes purpose, background, business common sense. Well, as to the judicial mood on this question, many practitioners had understood the sands to be shifting in the decades since ICS. And in very brief terms, there was a string of cases at House of Lords and Supreme Court level, and they are listed on the next slide. So after ICS came the judgments in Chartbrook and Rainy Sky. And many saw these judgments as elevating the importance of context and business common sense in the exercise of interpretation. And many were concerned about what they saw as the shift away from the natural or ordinary meaning of the words in the contract. And then came Lord Newburger's leading judgment in Arnold and Britain, 2015. Now, that case was understood by many, including Lord Sumption in his 2017 lecture, as the Supreme Court sounding the retreat from Rainy Sky and shifting the emphasis back towards the natural and ordinary meaning of the words. So after those various rulings from the highest court, where does the humble practitioner now find themselves in 2020? Well, the most recent word from the Supreme Court was in the 2017 case, Wood and Capita. And the Supreme Court there held that, contrary to what we may have thought, in reality, all the earlier cases were saying the same thing. So there were no shifting sands, and the approach has been the same throughout. Well, whether that was how it seemed to practitioners who were trying to apply these cases at the time is probably a matter of mere historical interest. But for now, the prevailing approach is set out in Wood. And it seems to me that there are 4 key takeaways. First, the Supreme Court affirmed the obvious, that the court's task is to ascertain the objective meaning of the language used by the parties. Second, the Supreme Court affirmed that in principle, it may be appropriate to look at, obviously, the wording of the particular clause and the contract as a whole, but also the factual background. Lord Hoffmann's judgment in ICS was described as celebrated, and it was clearly confirmed as authoritative. Third, and this is where it gets particularly interesting, the Supreme Court held that contractual interpretation is a unitary exercise involving an iterative process of checking each of the rival meanings against other provisions of the document and investigating its commercial consequences. And it held that once you've read the terms of the contract, it doesn't matter whether you start the detailed analysis with the factual background and the commercial context arguments, or you start the analysis with a close textual analysis, provided that at the end of the day, the court balances the indications provided by each of those investigations. Fourth, then, neither textualism nor contextualism has primacy. They are both tools to help the lawyer and the judge in working out the objective meaning of the contract. And whether a more textual or contextual approach will be appropriate in any given case will depend on the circumstances. So, if a contract is sophisticated, complex, and well drafted with the assistance of city lawyers, it might be successfully interpreted mainly by textual analysis. But if the contract is informal, brief, or even in a complex contract where difficult negotiating circumstances might have led to unclear terms, then there might be a greater emphasis on factual matrix. So the overall position is that when construing a contract, it will be necessary to consider the various factors outlined earlier: language, purpose, factual background, business sense. But where the balance will be struck between those various factors will very much depend on the circumstances. Now, the approach may be easy to state in the abstract, but its application may be less easy to predict in any given case. And as the debate that we're about to see may reveal, the correct approach to construing contracts will no doubt continue to challenge us all. I'll hand over back to Nick now.
Thank you very much, Charlotte. Paul, could we have the first example, just the next slide? So for the next part of this talk, what we were planning on doing is we'll show a few examples, and then Lords Hoffmann and Hope I'll ask some questions about them, and they can give their views. We'll start with an example from the Karen Altman, which is a 1976 case in which the relevant clause was that the owners let and the charterers hire the vessel for a period of 2 years, 14 days more or less in the charterer's opinion. Charterers to have the option to redeliver the vessel after 12 months trading, subject to giving 3 months notice. And so the key question there was, what does after 12 months trading mean? Is that at the end of the first year, or is it at any time during the second year? Could I just invite, first of all, your views, both of you, on this, just as a general question of construction, and then we'll get on to the relevance of the negotiations. I don't know who wants to go first.
What do you mean by the general question of construction?
Well, just the question that how one approaches this language after 12 months trading.
Hello?
Hello, David, can you?
Yes, can you hear me?
Yes, I can, yes.
Yes, I'd like to go back to Charlotte's introduction, if I might. Lenny may not remember this, but it was one of the golden moments of my time on the Law Lords corridor. We lived in adjacent rooms, rather like pigeons in a pigeon loft. And one sunny day, Lenny came out of his room just after we'd been hearing the investor's case with a piece of paper in his hand. And the facts were that Lord Gough, who was our chairman, wasn't particularly interested in the thing. Lord Lloyd was going off in the wrong direction. And Lenny had decided to take control of the case. And he produced this piece of paper. And on it were the 5 principles. What do you think of that? He said. And I must say, I was very impressed. And I said, well, that's pretty good. There's a great attraction to numbering things, 1, 2, 3, 4, 5. It all looked extremely orderly. And I thought we should go along with that. And indeed, slightly refined form, it came out in the judgment, and I agreed with it. So I've been an investor's sort of placeman ever since Lenny showed me his piece of paper. But I don't find this case at all difficult, this particular example, because if you stop, can I go back just one step? I think each case is different, and therefore when you're looking at these tests, you're going to be bound to be guided by the context in which you're looking at the things. And in this case, I think if the thing had stopped at the word redeliver the vessel after 12 months trading, it would have been perfectly clear. Do the word subject to giving 3 months notice make any difference? I don't think so. And to change the word after to something else seems to me to be all wrong. So I think it's a very straightforward case, and I would read after in the ordinary sense and say that the obligation was to give 3 months notice if we were going to redeliver the vessel after 12 months. But after that, it was all over. I don't know whether Lenny would agree with me, but that's the way I would look at it.
Yeah, I entirely agree with David's view on the construction of the case. I don't recall the incident which David referred to, but it may well be true. This particular case, the Karen Altman, is of course most famous because it raised the question of the rule that you're not entitled to take into account previous negotiations between the parties. And that is, at the moment, one of the rules of English law. We have rules as to what is the admissible background against which you can construe the contract. For the most part, it is, as stated in the investors' compensation case, what the parties may be supposed to have known at the time when the contract was made. But we have this rule which excludes their previous negotiations, which certainly was something they would have known all about. It's a rather disputed rule, and there isn't really a strong case being made out either for it or against it. And it's been around for so long that when we did have the opportunity to say, no, we're going to dump it, we decided that it wasn't really for us to do so. But this is one instance. You also have other rules about what background is admissible. For example, in bills of lading and in letters of credit, very little background is admissible because the person who is going to act upon the bill of lading or the letter of credit can be supposed not to have been aware of what the background to its issue might have been. Likewise with articles of association of companies. Again, you've got very limited background because these things are put in the register, and you can't really take into account something which a person reading the register wouldn't have known about. Now, those are the only, may I say, these are the only rules that we have for interpretation. Once you've decided what is the admissible background, there are no rules at all. You simply decide what the words mean, what the document means. And all this discussion about whether you take a more liberal or less liberal view or something like that, everybody emphasizes in all the cases that it all depends upon the facts of the case. You decide. Now, there are, of course, certain propositions of common sense which will enter into your interpretation. For example, as a matter of common sense, you would assume that if they paid lawyers to draw up the contract, the lawyers will have drawn it up with some care and won't have left things out which are important and won't have used the wrong words. You assume that as a start. You have, if you're in doubt as to what the meaning of the document is. You bear in mind the general policy of English law, that there should be certainty about what contracts mean, and that certainty is probably best given by saying, well, it means what it says. All that. But in the end, you're simply deciding a question of fact. You're not deciding anything which is governed by anything that can be described as a rule of law.
Well, I'm grateful to Lenny for pointing out that actually the case was all about whether you look at the prior negotiations, and I'm afraid I applied the rule. And the rule was devised in Scotland, as it happened, way back more than, it was in the 19th century, wasn't it? Sometime in the 1870s or something like that. And they were really turning their face against what nowadays we would call satellite litigation. Because once you don't have a rule like that, you open up a can of worms, really. And there's a good deal of discussion. Evidence will have to be led. Of course, they'll disagree as to what the negotiations said. And you could get a considerable amount of useless litigation. And it was really turning their face against that, which led to the rule. And the rule is, as you say, we looked at in Chartbrook and decided we should leave it as it is.
That's right. Yeah.
There was a tendency for some time for parties to run a rectification claim in parallel with arguments on construction to try and sneak in evidence of negotiations. Even though they may not win on the rectification claim, they wanted to get that stuff in front of the court and try and pollute the judge's mind. Is that an effective strategy? How?
Well, in the Chartbrook case, Brenda Hale admitted it was effective with her. She said expressly that she was reinforced in the view she'd come to by the fact that she'd been able to see the prior negotiations. And I don't, maybe not everybody is probably as open and honest as that, but she certainly thought so.
Well, I mean, one wouldn't stop a rectification case if it was justified. And I think one of the justifications for the rule is saying, well, there are two ways around it, of course. In a proper case, it could be a estoppel by convention. Or it could be a justification claim. So it's not a rule without remedies in a case where it would lead to injustice. I think that's an important point to bear in mind as well.
That is so. You can say, well, I think that's what it means, but even if it means what the other side says, we would rectify it.
Is there a kind of halfway house where you've got, obviously within estoppel by convention, you have to show a shared assumption that's communicated between the parties in order to make out the estoppel. But is there a sort of class, as it were, below that that is still worthwhile by way of a kind of bogus rectification claim in order to get this material before the court? Or is there no gap between that and issues of construction?
So I mean, you know perfectly well that for the purposes of construction, one is not supposed to have regard to prior negotiations which may have been introduced for the purposes of rectification. And you are hearing them all together, and therefore it calls upon the judge to perform some mental gymnastics to dismiss from his mind the matters which he's learned for the purposes of rectification. I remember my predecessor as a judge in the Chancery Division was Mr. Justice Goulding. And he was the only person I ever knew who, when he used to say in court, I put that out of my mind, actually was able to do so.
Yes. Yes, in criminal cases, one used to tell juries to put things out of their mind. And they were so shattering that you couldn't possibly do that.
So if we weren't bound by some of the earlier authority and were reinventing the law from scratch, do you think there's a place for pre-contractual negotiations if they are directly on point? I mean, a way of trimming them down, or do you think that actually the present rule is the right one?
Well, we thought that there's a balance to be struck between the amount of effort that would be put into bringing all the pre-contractual negotiations before the court, possibly a great thick file, and the number of occasions on which it would really have any effect upon the decision on construction. And the impression, I mean, Lord Wilberforce, going back to 1979, I think, said, well, the basis of the rule is that it's all a waste of time. And there's probably a lot in that. So this is a practical decision on which I didn't think we had sufficient information to be able to change the law.
There is some benefit in the law anyway. I mean, I think one would think that people who are drafting contracts ought to put their minds to the contract. They're supposed to set out in a carefully reasoned way in a formal document what the parties have agreed. And to allow them to slide around that and say, well, sorry, I didn't really mean that, we negotiated in a different way, is sloppy practice. I think one would try to steer away from that in the interests of the orderly performance of the law.
Thanks very much. So can we move on to the second slide, Paul, the second example? So this is a clause from Arnold and Britton. This was to do with the service charges in relation to, I think it was a caravan site. So the lessee covenants with the lessor for the benefit of owners during the term to pay the lessors without any deduction in addition to the said rent a proportionate part of the expenses and outgoings incurred by the lessors in the repair, maintenance, renewal and provision of services hereafter set out in the yearly sum of £90 and VAT for the first 3 years hereby granted, increasing thereafter by £10 per 100 for every subsequent 3-year period. So there were two very different approaches to that clause in the case, one in which £90 was a maximum, and the other in which it was a fixed charge subject to compound interest. On the latter construction, by 2015, the charge would have amounted to £2,500, and by 2072, it would have been £550,000. What are your thoughts about how to strike the balance between a strict application of the contractual language and looking at some of the sort of wider issues that are identified in ICS? I mean, how do judges go about trying to work out which scenario, how best to balance those interests?
Can I come in?
Yes, come on, David.
I don't want to jump ahead of you. I'm reminded of a rather nice comment by Lord Roger, who was saying when you look at a difficult thing like this, he was reminded about translating a document written in a foreign language. And he said the best way of dealing with them is to look at the easy parts first. And having found out what they mean, you probably find you can get through the other parts as well. And this one is a little bit like that. I thought that if you read down to the words hereinafter set out, it's fairly easy to see what the clause is driving at. And then what I would expect next is a definition as to what the proportionate part is. And that's what you find in the following bit from the yearly sum onwards. So it's a bit of sort of parsing that's required here. And if you look at it that way, I would have thought the answer is relatively easy to reach. And I'm not applying any particular rules here, apart from looking at the language and trying to reconstruct or try to deconstruct rather a slightly confusing bit in a document. And it's a question of parsing them, trying to find the easy bit, as Lord Roger said, and then see if that leads you to a satisfactory answer.
So, Lenny, do you have any thoughts on?
Yes, I think I agree with what David has said. I would have read this to mean that you increased the maximum, not that you increased by compound interest, so to speak, the amount payable. But I think there was a dissent in this case, wasn't there?
There was. So Lord Carnworth dissented and said that he thought that something had gone wrong with the drafting and there was an inherent ambiguity, which he wanted to solve in the appellant's favour because the respondent's interpretation was so improbable commercially that only these words would justify that outcome.
I think I'd have probably agreed with Lord Carnworth, but the principle is clear enough. I mean, that you read the thing in accordance with the ordinary rules of language and English grammar, unless you think that produces a result which either contradicts some other part of what the parties have agreed, or is really so off the wall that you think it couldn't possibly be what the parties meant. And obviously, on that, both those questions, the views will differ. But there's no great issue of principle about it.
No, I agree with what Lenny's just said. I mean, if you're using a rather loose phrase like commercially improbable, then you're having to make a judgment. And I think that's what happened here. Lord Carlos was just simply, on his own on that, his judgment was that it was so improbable that you really had to sort the thing out and come away from the language, whereas Lord Newburgh and those who agreed with him were taking the language as it was and saying, well, it's sufficiently clear what they mean, what the words mean. So I don't. Do we get any refinement of investors there? I think it's a straightforward application of the thing, although Lord Rogers' approach is helpful in unraveling a rather complicated formula.
I mean, I think that this case gives the suggestion, it suggests to me that it's got some of Jonathan Sumption's fingerprints on it, because Jonathan, as explained in the article that Charlotte referred to, is a linguistic fundamentalist. And he thinks that there is actually some rule of law that you have to give words their dictionary meanings, and that you have to apply the sort of English grammar as it would be in a grammar book. And no allowance should be made for the fact that people occasionally get these things wrong or don't express themselves very well. Whereas, as far as I'm concerned, the object of the exercise is to find out what they meant. Nothing more than that. And quite sometimes, for reasons we'll come to in a moment, I don't think it will be very often, but sometimes you can see that they've not expressed what they meant in the appropriate language.
Is the fact that a contract is a product of professional advisors something that you should take into account when you're assessing how how closely you should stick to the exact language? I mean, do more exacting standards be applied to professionally drafted texts, or what's your views on that?
Very much so, I think, that you take that into account. If we look at, for a moment, let's have a look at one of an example a little further on, about the tickets for the Wigmore Hall.
Yeah, Paul, could we go to the example 4?
Now, look at the bottom one there. Robert's a friend of the Wigmore Hall, and he's entitled to priority booking. And his friend Matthew's come to dinner, and they're talking about a forthcoming recital by Sir Andrew Shipp. Matthew says, I think it will be sold out before the general booking opens. Do you think you could get me a ticket? And Robert says, yes, certainly. And the issue then is, well, did they mean by that conversation that Matthew would pay for the ticket, pay Robert for what he spent on getting the ticket? And in ordinary language, people always speak elliptically. If you go and listen to President Trump on the television or something like that, it's all elliptic and things are left out. And anybody having heard this conversation would think, well, obviously the intention is that he should pay him back for what he spends on the ticket. There's nothing to suggest that he was asking for a gift. But assume that these people had gone off to a lawyer and said, we've made this agreement over dinner, but can you please draw it up as a legal document? It would then have come out something like, well, Robert will use his best endeavors to obtain a ticket for the Wigmore Hall and will deliver it to Matthew within a reasonable time before the performance, and Matthew will thereafter pay him what it cost and so forth. Lawyers are there to spell things out, to cross T's and to dot I's, and therefore you approach a document drafted by lawyers with the assumption that they've put all the important terms in. A lawyer's document is much more susceptible than a conversation like this to the question, well, if that's what they meant, why didn't they say so? In a conversation over the dinner table like that, you wouldn't say a thing like that if that's what they meant. Why didn't they say so? But you frequently say that when you come you come to a document drawn up by lawyers. That's one aspect of it. Another aspect of it is that if there is a general policy of the law that the contract should be capable of to give rise to obligations with some certainty. If you're left in doubt as to what the contract means, you give your best way to give certainty if you stick to what the ordinary meaning of the words is. And that is a question of policy to be taken into account. But in the end, in both cases, whether it's what happened over the dinner table or whether it's a legal document, it's a question of fact. I know in English law it's not a question of fact because it's treated as a question of law because juries used to be illiterate. But for practical purposes, it's a question of fact.
Well, I think it's a rather lovely example you chose, Denny. It reminds me of Johann's lecture. Do you remember? I think it was a published article of his, The Reasonable Expectations of Honest Men.
Yes.
And he was saying, well, even in choosing between alternatives, well, you look at the contextual scene, and this is just a casual conversation. Lawyers are not prescribing what to be.
Can I also add that this conversation here is an example in ordinary life of an implied term. And an implied term is no different from interpreting what the parties, the language that the parties use. In both cases, what you're trying to discover is what did they mean?
Yes. And well, I think one thing you could also say, what did they not say? I mean, what did they mean? And the thing that he was really interested in was getting a ticket. Who was going to pay for it wasn't what they were discussing at all.
No.
I think that's the context.
It's clear what they must have meant.
Yes.
Do you think Lord Neuberger in Marks and Spencer said that when he was talking about the balance between interpreting an agreement and implying a term, that they were different process governed by different rules, and when one's implying a term, one's construing words.
That's nonsense. It's what are the different rules? I mean, again, I think that Jonathan Sumption's influence is there because he says you can't interpret words that aren't there. Well, you're not interpreting words; you're interpreting the utterance as a whole, and you're saying what does it mean, and that takes into account things which the parties have not spelled out just as much as things which they have.
So do you think the distinction that the Supreme Court set up in Marks and Spencer is overly, as it were, clinical, or how would you? What's your views on that case?
Well, I don't think it makes sense to say that. Again, you see, if the reason why in implied terms we talk about necessity and all that kind of thing is because if lawyers draw up a document, you don't expect them to leave things out. And you say, well, if that's what they meant, why doesn't the document say so? And therefore, it's only if you are absolutely clear that they must have meant something they haven't said that you will imply it. But that's not a legal proposition. That's a proposition of common sense about the way lawyers work.
And are you, Lenny, I wasn't quite clear, are you saying there's an implied term in your second example here that
Yes.
that Matthew, that Robert would pay, sorry, it was Matthew, getting it right way around, Matthew would pay for the ticket. It's an implied by what the conversation is about.
It's an implied term, yes.
And it's because, I think, am I right in saying that if they'd actually got round to asking who's going to pay for it, if they'd asked themselves that question, it would have been quite obvious that Matthew would pay. But they didn't ask that question because it wasn't the issue they were concerned with.
Yes, it's something that they was not expressed in words, which is what an implied term is.
Mm-hmm.
Obligation not expressed in words.
Could we go back to the third slide? So this was so this example 3. So this is the language in the Antios. One of the issues there was how to go about construing this clause, failing the punctual and regular payment of the hire or on any breach of this charter party.
Yes.
So the question was, did it mean any breach at all, no matter how minor, or did it mean one that was so serious that it deprived the owner of substantially the whole benefit of the contract, in which case it was pretty much the same thing as repudiation?
Yes. And Lord Diplock thought it must mean a fundamental breach because it would be extremely foolish if it provided for any little breach.
Yes,
that's a legitimate.
I thought the interesting thing about this case actually was that it was the arbitrators who had the first go at this meaning, and they thought that in the context, having regard to the form, I think it was, that was being used, it couldn't mean any breach. It had to be something substantial. And then it went through the various judges. I think the Court of Appeal the judge was a bit doubtful about this, but he allowed the case to go forward. And then Lord Diplock got to work and said it was quite obvious what what was meant. But it was the arbitrators who really saw through this and took the context into account in deciding what the words meant, which I think is consistent with investors.
Yes.
There's an interesting example where I think if it had not been an arbitration, possibly it might have gone a different way.
I must say, I agree with Jonathan Sumption that Lord Diplock's famous remark was a bit of a hostage to fortune. I mean, it's simply not the case that every agreement must be made to yield to common sense. People enter into agreements which no common sense person would enter into. And nevertheless, it's perfectly clear that that is what they meant. So I think Lord Diplock was over-egging the pudding. But if you reduce that to saying that business common sense is something which you must take into account, then that's perfectly okay.
Yes. He got very upset about the length of the arbitrator's award. Did you spot that? I think it's 76 pages just arguing about what the word any meant.
Yes, there was a criticism containing far too much reasoning.
Yes. Well, you do see that sometimes.
How does the court go about striking a balance between the language of the contract and business common sense when they point in different directions? I mean, obviously it's quite difficult to say that there's a threshold where you should cross in one to the other. But if you think, for example, about Lord Carnworth's dissenting judgment we were talking about a moment ago, obviously he felt that business common sense dictated against that particular construction. Is this just a question of impression, or are there more things that you...
I don't like the idea of business common sense being erected as a principle and somehow in conflict with what the parties have said in the document. I do think that the exercise in every case is to decide what the parties must have meant. And if you find that it is so contrary to business common sense that they obviously must have got their language wrong. Not that you've got to distinguish always between whether that is what they meant and whether in the events which have happened, that has turned out to be a rather silly thing to have entered into. And so you've got to be able to look at the document and look at the surrounding circumstances and say, if I give this a literal meaning, it can't be what the parties meant. And business common sense is, you can say, one of the factors you take into account, but nothing more than that.
There could be cases, though, couldn't there, Lenny, where actually it's a draw. If you're looking at just the words themselves, it could go either way, quite respectably either way. And then you would say, well, does business common sense help us to resolve the draw? And you would lean in favor of business common sense in a situation like that.
That is, of course, the easy one. And I mean, even Baron Park would have agreed that if the words are ambiguous, you look at business common sense as the factor to decide which way it's supposed to go. What people find more difficult is where the words are not ambiguous, where you've got to say, well, they used the wrong words.
And then you get to, you're back to Lord Carnwath's situation, where he thinks it's so ridiculous that you have to go one particular way, and the others disagree with you. So it comes down to a situation where it's not a very useful tool on its own. You've got to look at the context in which the whole thing crops up.
It's funny that almost all the cases I've come across in which people have got things wrong, made a mistake, ICS, Chartbrook, and also Lord Carnwath's case, is where they've tried to express what might have been better expressed as an algebraic formula in ordinary language. And somehow or other, they always tie themselves, well, not always, of course, these cases are very rare. I mean, they come once in a decade. But they then tie themselves into knots. I remember having a case as a judge of first instance in which the surveyors between them drew up a formula by which the lease was to be calculated, and there was a perfectly good formula, but the solicitors then tried to put it into language, and they got it entirely wrong. And so the contract was drawn up, not expressing what the surveyors had agreed. Then after that, they actually drew up the lease, and somehow in drawing up the lease, they noticed that it had gone wrong, and they restored what the surveyors had intended. And then there was an application for rectification of the lease on the grounds that it didn't accord with the contract. Well, it didn't, but it was what the parties had intended.
Yeah.
Can I just ask about, so is there, to what extent is the matter of impression? I mean, I'm just trying to explore the litmus test about when as a judge you feel that something has gone wrong as commercially. Is that something that is? Do you feel that different judges approach these types of clauses in very different ways, or how is that something that you're trying to?
Different judges will. I mean, all questions of construction tend to be matters of impression. And the judges frequently disagree on questions of construction, and there's no way of avoiding that, I'm afraid. There's going to be no infallible litmus test that the counsel can apply, which will make sure that the judge in question gives the same answer. On the other hand, I think there has been a little tendency, led, I'm afraid, by Jonathan Sumption, to take an altogether different view of how you approach the question of construction, and to give an absolutely to give a primacy to the words that they've used, which simply cannot be displaced in his view. No, it doesn't matter how strong the evidence that they couldn't have meant that. You have to give effect to the words, and I don't think English law has ever adopted that. And even if you go back to the 19th century, they used to say things like, well, you've got to interpret it according to the language which they use, unless that produces an absurdity. That's what Baron Park said in the 1850s. Well, what counts as an absurdity? I mean, that's what we're talking about.
Well, I thought you put it rather well, Lenny. In your fifth point in ICS, I don't know you quite remember what it was saying, but it was saying that we do not easily accept that people have made linguistic mistakes, but if it's clear from the background that something must have gone wrong with the language, then judges will then deal with that and take account of it in deciding what interpretation should be placed on the words. So it is a question of one's not readily taken away from the words used, but there is a point at which you would, and that's where there's going to be a difference between judges, obviously, as to where they go. But that's a softening, which Sumption doesn't allow for.
As long as you bear in mind that the ultimate question is not what the words mean; it's what the parties meant. That's the critical distinction.
Well, that fits in with Johann Stein's thing that in the event of doubt, the working assumption must be the fair construction which best matches the reasonable expectation of the parties.
Yeah.
And you're making a judgment of what they expected from the language that they used. But I think Jonathan's position is far too harsh for me. I think it really doesn't really fit in with the ideal of finding a solution which fits best with the intention of the parties.
Yeah.
Can I try out another point which Jonathan makes on you both? So one of the things he says is that termination clauses are things that English commercial judges and Scottish commercial judges are generally traditionally quite hostile to, because they tend to be rarely invoked for the sorts of reasons that they were put in the contract for. People exercise them when it's opportunistic for them to do so. So, and judges, when they look at those sorts of clauses of termination, are sometimes concerned about the fair result being achieved as much as they are about construing the language. Is that a fair comment, or how do you think termination clauses are a special case?
Yes, it certainly accords with what actually happens. I'm not sure it's if you remember, there was a case called BCCI and Ali somewhere around the turn of the century, and it was a case in which we had to construe a clause in which one of the former employees of BCCI gave a release of any claim that he might have. He was paid out, and he gave a release. And I was in a minority of one in that case, in which I said, and ironically, I said, well, if you read the release, it covers what he did. And my four colleagues said, no, it can't be read to that, because it covers, if you read it literally, it covers things which he couldn't have imagined at the time would be claims that he might make. And how could he be giving up claims which he didn't think that he had? So it's slightly ironic that I should have been the one to insist upon the literal meaning of the words, but there it is. It is, I think, you find the same thing in the old-fashioned approach to exemption clauses, which were also treated as being, and in fact, at one stage, Lord Denning converted that into a rule of actual law, that exemption clauses become void if they deprive you of the right to sue for a fundamental breach of contract. And he was put right on that by Lord Wilberforce and Lord Diplock in the Photo Productions case, in which they said, no, you've got to see what they actually meant. There's a thing called the Unfair Contract Terms Act now, which enables you to deal with when they're unfair. So just stop trying to do it through construction. But there is that tendency, I agree.
Is this a situation, Lenny, where you take account of the fact that trained lawyers have been drafting the document? That, there's a strand sometimes.
I think you always take that into account. You always, it must be a factor to take into account that you've had a legal advisor whose business it is to draft documents, and he's drafted the document in that way. And so it's very difficult then to say, well, no, he's got it wrong. They usually get it wrong when they try and reproduce mathematical formulae.
David, do you think that it justifies a special approach for termination clauses, or do they present particular problems? What's your thoughts on that?
I've not had a case to actually apply my mind to in that thing. I'm not sure I can add anything to what Lenny's been saying, really. I'm rather against elevating these things into special cases. I think they fall into a package, really, of applying fairly sensible rules across the whole spectrum of contractual problems. I mean, one can get too bound up with putting things into packages and say, well, you look at box A and box B and box C. I think really one should take a broad view across the whole spectrum of these ideas.
This is, I mean, this is one of which the Antaeus is an example, yes, that they give a narrow construction to it. But that seems to be a legitimate approach if you've got a clause like in the entails, to say, well, could they really have intended that this termination clause should apply to, and then Lord Diplock gives various examples of trivial breaches.
Yes. Well, I mean, as I say, that one was very carefully sorted out by the arbitrators anyway, looking at the whole context.
Yeah.
They reached the result which really one couldn't disagree with.
So just moving on to a few more general points. I mean, what practical advice would you offer to litigants? Do you think people strike the right balance when they're dealing with the matrix of fact, or are they? I mean, some cases you get very little information by way of matrix of fact, and then you get into a knotty textual construction question where perhaps some more work on the matrix of fact might have assisted the tribunal in deciding the issue. Is that your experience, or are there other particular tips that you might have, or what's your thoughts?
I think that cases like ICS and Chartbrook, where the court comes to the conclusion that the draftsman has got it wrong, are very rare. And and so for the most part, virtually all cases are decided simply on the ordinary language of the contract. There must be something rather special that appears to have gone badly wrong. You must look at this and say, can they really have meant that, before you start digging into what the background is and all that.
Well, that's, I think, what you were saying in Investor's case, that we don't easily accept that people have made mistakes.
Yeah.
But of course, the trouble with litigation is you've got a client behind you, and sometimes the stakes are so high that they'll say, look, let's have a go at this, see what's going to come out of it. You can't tell a client, well, there's absolutely no chance whatever. Okay, I'll let it run through first instance at least, and see what the court makes of it.
Of course, that applies to not merely to points of construction. There are all kinds of try-ons if the stakes are high enough, like election petitions.
So, I mean, you're asking, Nicholas, what advice you should give. Well, ultimately, that's got the great advantage a barrister has over others, is you can give advice the client doesn't like. There are times when really the stakes are so high that it is worth at least a first instance go and see whether actually the thing might work out. So that's how litigation tends to work.
No, I have to say, as an advocate, that's all very encouraging.
So it is. In some ways, it's one of the good things about the common law that actually, you can argue about these things. It's not a code. It's not, and so there is the room for exploring, as we've been doing. And if you come to the conclusion the law is actually fairly sensible as it worked out, that doesn't mean to say it hasn't been worth giving it a shake over to see whether there is something wrong. But we can do that in our system, which is very healthy.
Yeah.
I suppose a final question, well, for all three of you, I don't know. Is there any aspect of the current approach that's taken by the courts that needs to be updated or changed, do you think? I mean, we've spoken about the test on implied terms, but in terms of construction, is there anything else that was it completely right in ICS? In reflection, there's no change, or with hindsight, are there aspects you would have revisited?
I thought that looking at those propositions that Charlotte put up from Wood and Capita, and there was nothing there that I would disagree with. I mean, that seemed to me a perfectly legitimate way of approaching the matter. As I told you earlier, I disagree about the way in which implied terms were categorized in Marks and Spencer, but that's a theoretical objection, and in fact, I mean, doesn't produce any practical differences.
Well, for my part, I'm fairly comfortable with the way things have settled down. One's always going to get a case which makes one think about it, the context being different, and the argument has to be looked at again. But I wouldn't want to stray far away from what we've settled since ICS, and which has been affirmed since then. Rainy Sky was, you know, I'm not quite sure that one really attaches much importance to Rainy Sky these days, really, but it was not really taking a different line, was it, Lenny? It was just Lord Clark was sort of introduce a thing in the judgment which would just touch the point and leave it there. He wasn't laying down.
I'm not sure I'd have gone the same way. Not sure I'd have gone the same way on Rainy Sky, but again, there's no point of principle there involved. It just strikes different people in a different way. Yeah.
Yes, I think people perhaps tend to perhaps attach too much importance when they can find subtle differences between the judges who are trying to explain the same thing. It's got to be very careful about drawing out on a sort of tangent by perhaps a slightly inaccurate word in a formulation.
There was a case in the Supreme Court the other day in which I forget who it was a unanimous judgment by someone, and he said, well, obviously here the language has gone wrong, and so we can give it what we thought it was intended to mean. And he quoted Chartbrook. And this just passed without comment. I mean, nobody thought this was an heretical thing to do. They corrected the language.
Yeah.
I suppose just a final question. I'm not sure if you heard the session this morning about the implication of terms on the basis of good faith in commercial comments of contracts. It'd be interesting just to hear your views on that. Finally, I don't know whether.
What about the implication of terms of good faith?
Yeah, I'm saying. I mean, should the Supreme Court grasp the nettle and imply that sort of relational contracts, imply those sorts of terms as smoothly as it has?
I think that's a situation in which it's probably easier to imply a term than it is in many contracts, because how would the parties have spelt it out? I mean, it's you don't really expect them to say, and they will not absolutely try to cheat each other, etc., etc. You wouldn't expect that to go into the contract. So I find it much easier to imply a term of good faith in a suitable contract, bearing in mind what Lord Ackner said about the parties' interests being opposed to each other, which always puzzles me about how it could be said that the Brexit negotiations are not being pursued in good faith when each of the parties, as Lord Ackner pointed out, have opposing interests to defend. But yes, I think I entirely agree with the implications in those cases.
It's very interesting to me as somebody who has a civil law background coming from Scotland, where we've never had any problem about good faith. I think some years ago, English law was rather suspicious of it, Lenny, I think, and thought, well, this is a rather unruly animal that we don't really want to allow into our system. So personally, I'm glad to see that carefully looked at it has a place.
I thought there was great force in what Jasper Dillon said earlier about one of the selling points of English law being that we do not have a doctrine of good faith. I mean, you want to come across some of the arbitrators I've sat with from continental jurisdictions as to what they're willing to do with the terms of a contract on the grounds of good faith. And I think that that would reinforce what he said.
Well, I did say carefully controlled.
Yeah.
One doesn't want to have the thing run away with them. But as a general idea, I would have thought it does have a contract.
But if you can rely upon judges to apply the doctrine of good faith as appropriate and so forth, of course it's a good idea to have a doctrine of good faith, and I'm sure it works very well in Scotland. But I think that what businessmen are concerned about is arbitrations. And they regard a doctrine of good faith as giving a license to arbitrators to impose a solution which they think fair.
Yeah.
Well, good certainty should triumph. I think rather than good faith, perhaps.
Businessmen, yeah.
Well, thank you very much, all three of you. I think we're probably out of time now, but it's been a great privilege to hear from all three of you and your views. And I can't see any questions that have come through. In which case, I think we'll call it a day there. Thank you very much.
Very entertaining to look back on some old cases which we heard some years ago. It's quite nice to be reminded of these things from time to time.
Yes, thank you very much.